Welcome everyone to Parting is Such Sweet Sorrow, Leaves of Absence and Benefits Compliance Considerations. Thank you all so much for joining us. Our moderator for today's call is Diane Cross. She will be answering the questions you send through the Q&A today. We will try our best to answer all of your questions, but if for whatever reason we are unable to get to your question today, please follow up with your advisor for further assistance. Today's presentation is being recorded. We will be sharing the recordings in the GetWise Wednesday emails and on the NFP website. If there are any portions of this call that you missed, by Friday, you will receive an email with a link to the full recording. The PowerPoint slides during this presentation will be shared in the same email. Additionally, for those who are certified with your PHR, your SPHR, or your GPHR, this webinar is pre-approved for a 1-hour recertification credit. In 24 hours, I will email the program ID number for you to record and submit to the HR Certification Institute. This credit will be only available to those who listen to the actual webinar, not those listening to the recording later. Additionally, you must remain on the call for the entirety of the webinar to be eligible for the credit. At this time, I'd like to introduce our speakers for today's webinar. Joining us today are Jill Brooking, Vice President, and Patrick Myers, Vice President and Counselor for NFP's Benefits Compliance Department. We are very excited to have them speaking with us today. It is my pleasure to hand the call over to our speakers. Patrick, the floor is yours.
Thank you so much, Amber, and welcome everyone. Thank you for joining us today for Parting is Such Sweet Sorrow, Leaves of Absence and Benefits Compliance Considerations. We are your presenters, and my name is Patrick Myers. I'm Vice President and Counsel with the NFP Benefits and Compliance Group. And with me today is Jill Brooking. She's also the Vice President with NFP Benefits and Compliance. Our moderator is Diane Cross. So all this knowledge and looks to, it's going to be the complete package today. But first, let's go through the usual disclaimer. Please note that we are giving general guidance today. We do not intend to be giving legal advice, and it's because it's not a dispositive position on coverage. Each claim is subject to review by the applicable insurer, and coverage is dependent upon the terms and conditions of your specific insurance policy. So today we're going to walk you through some major areas of leaves, and we're going to start by talking a little bit about the leaves that have been granted by the Families First Coronavirus Response Act, and then we'll discuss FMLA considerations, ADA considerations, and general benefit considerations, and then we'll wrap up by looking ahead to see what may be in store for us later on this year. So let's start with talking about FFCRA. As a recap, you may recall back in March of 2020, Congress passed the FFCRA, which was a package of coronavirus relief measures that affected many aspects of the federal government as well as state government. But we are concentrating today on that portion of the FFCRA that dealt with some emergency paid sick leave, as well as some extensions to the standard FMLA leaves. Under the FFCRA, employers with fewer than 500 employees were required to provide up to 10 days or 80 hours of paid emergency sick leave, which employees can then use for any one of a number of specific reasons that were enumerated in the statute. Most of them related to the coronavirus, including things like if you are actually sick with the virus, or if you are attending somebody, a family member who is sick with coronavirus. The FFCRA also provided an extension to the FMLA. It did not add more weeks to the FMLA, but what it did do was provide 10 of the 12 weeks paid if you're using the FMLA for a specific reason, which was to tend to a child or other dependent who could not go to school or daycare because of the coronavirus. Under the original iteration of the FFCRA, this was required for those employers with fewer than 500 employees until December 30th of 2020. Then in December of 2020, Congress passed its Consolidated Appropriations Act, which, among other things, made the emergency paid sick leave and the extended FMLA, extended it to March 31st, 2021, but it became optional. Employers no longer had to provide it, but they could if they wished to. The other thing I want to point out at this point in this particular extension is that it did not add any more hours to the emergency paid sick leave. It simply provided more time for employees to use those hours before the expiration date of the extension. But it was extended to March 31st, 2021. Then in March of 2021, the American Relief Plan Act extended these leaves again until September 30th, 2021. Now, under all of these different iterations of the FFCRA leaves, employers would be responsible for paying the employees when they take these leaves. However, the employers are reimbursed for providing this leave through tax credits. The credit is allowed against the taxes imposed on all wages and compensation paid by the employers to the employees. If the amount of the credit exceeds the employer's share of these federal employment taxes, then the excess is treated as an overpayment and refunded to the employer. And employers could obtain this credit in advance. So if you're an employer and you're considering using these leaves under the FFCRA, the first thing to do is to understand the options that are available to you. Now, the FFCRA has been extended, as I said, to September 30th, and it is more or less the same as it has been since the beginning, since March of 2020. It applies to employers with less than 500 employees. It provides these employees with the paid leave, emergency sick leave, as well as that expanded FMLA. And the rate of pay for leave is 2/3 of normal pay, up to $200 per day for the childcare related reason. And then the normal rate of pay up to $511 per day for any other reason enumerated in the statute. However, the new extension that extended it to September 30th, did add a few tweaks. Namely, it added more hours to the emergency paid sick leave. Recall when I mentioned the initial extension to March, it did not add more hours, it simply gave you more time to use the hours originally granted. If the employer opts to extend it to September 30th, starting April 1st, they get a whole new 80-hour set of emergency paid sick leave to use. In addition, the extension to the FMLA increased so that all 12 weeks under the FMLA can be paid if it is taken for that reason. That is to say, if it is taken to take care of a child or dependent whose daycare or school is closed due to coronavirus. In addition to those changes, the extension under ARPA also added a couple of new reasons that employees can take these leaves. And that included all the original reasons that were granted under the original version of the FFCRA. But in addition to that, it also included reasons for basically relating to taking the vaccination, getting a diagnosis, or recovering from the vaccination. Finally, as I mentioned earlier, these are all optional to the employer. And the option is not just limited to whether or not you extend the FFCRA leaves. You can offer only the emergency paid sick leave or only the extended FMLA or vice versa, but not necessarily both, or you can offer both. You can offer for a period of time shorter than the maximum amount allowed under the extensions. So if the employer opted to only offer it through July 31st, they could do that. Now, they can also, of course, because it's totally optional, the employer does not have to offer their employees these leaves. However, there are state considerations to keep in mind. So the next step to think about, the next step is to consider those state and local requirements. Many states over the course of the last year or so have also either enacted statutes or ordinances that either mirror or expand upon the leaves that are granted under the FFCRA. We'll go over a few examples of those here shortly. So as I mentioned, many states, cities, and counties have adopted their own leave laws. And these, unlike the FFCRA extensions, these are going to be required and not optional. They'll vary as to the size of the employer, the duration of the leaves, and the effective dates. So if the leave qualifies for state, local, and FFCRA, the employer can still apply for a federal tax credit. So with that in mind, we'll go over through a few examples of some of the major states that have enacted leaves. A big one, of course, is California, SB 95. This is a statewide law, and it applies to employers with 26 or more employees. These employees are eligible for paid leave for the number of hours they typically work in a 2-week period up to 80 hours. The leave allotment is in addition to any normal PTO, paid leave, or mandated safe and sick leave. The employees can take this leave for reasons similar to those in the FFCRA, and they are also paid their normal rate of pay up to the maximum of $511 per day, very similar to the FFCRA. Now, the law is effective retroactively back to January 1st of this year and is in effect through September 30th, much like the extension to the FFCRA. Now, not content with just the state version, several local California cities have also enacted their own ordinances, and here are a few of them. In Oakland, there's an ordinance that applies to employers with 50 or more employees and requires them to provide up to 2 weeks of paid leave for employees who are unable to perform work, including telework, for COVID-19 related reasons. These employees are eligible if they performed at least 2 hours of work within the city of Oakland after February 3rd of 2020. Full-time employees, that is those who average 40 hours a week, are eligible for up to 80 hours of paid leave, with part-time employees eligible for their average hours worked over a 2-week period. Employees, much like the other leaves, must be paid normal wages up to $511 per day. In addition, health benefits must be continued during this leave period. In Los Angeles, the ordinance there requires employers with 500 or more employees nationally to provide paid sick leave to employees who work in LA County, and that includes the unincorporated areas of the county. Employees do not need to satisfy a service requirement in order to get this leave. They only need to be employed during the period covered by the ordinance. Eligible full-time employees can receive up to 80 hours, up to the daily max of $511, and part-time employees may receive paid sick leave based on the average number of hours and pay rate for a new 2-week period during the eligibility period. Another big one is from the District of Columbia. Their Emergency Amendment Act added a new category of leave to the existing DC FMLA. And this is the Declaration of Emergency Leave. And it's available to employees who are unable to work during a period of time where the mayor has declared a public health emergency. And the employee has self-quarantined or isolated due to a recommendation or order by a healthcare provider, federal, state official, or the mayor. But unlike the DC FMLA, the Declaration of Emergency Leave applies to employers of any size with an employee performing work in the district. Employees do not have to meet any service requirements to be eligible, and the amount of unpaid leave is indefinite for the period of the public health emergency. Massachusetts also has a very similar statute. And in that statute, all employers, regardless of size, have to provide up to 40 hours of emergency paid sick leave to Massachusetts-based employees. That is, those employees whose primary place of employment is in the state, who experience a qualifying reason. And those are very similar to the FFCRA reasons. The statute establishes a $75 million fund that will reimburse eligible employers for the cost of providing this additional time for their employees. So that's an interesting wrinkle to the usual way these things are funded. Now, the leave is available from May 28th of this year through either the earlier of September 30th, 2021, or the exhaustion of the fund. In New York, there are two major statutes that apply here. The first is S8091, and that requires New York employers to provide sick leave and job protections to employees who are quarantined as a result of the pandemic. It also serves to supplement the FFCRA and protect employees to the extent not covered under the federal legislation. So it kind of covers all the gaps that were created by the FFCRA. An employer with 10 or fewer employees and a net income of over $1 million, or an employer with 11 to 99 employees, must provide at least 5 days of paid sick leave and then unpaid sick leave for the remainder of the quarantine or isolation. After the 5 days, however, the employee is eligible for PFL and short-term disability benefits. Now, an employer with 100 or more employees or a public employer must provide at least 14 days of paid sick leave during any order of quarantine or isolation. Accordingly, and in contrast with the federal leave, the state law applies to employers with 500 or more employees. And finally, the other big one that New York has is S2588A. And this one is the one that requires employers to grant employees up to 4 hours of excused paid leave per injection that cannot be charged against any other leave. So this is the leave that they can take to get the vaccine, basically. Accordingly, the legislation enables employees, including essential workers, to take time off to get vaccinated without exhausting any leave that they have already earned. Now, these are just a handful of examples of states that have promulgated these statutes and ordinances, and there are many states, other states that have also done the same. And we're not going to be able to go over all of them today, but we do have a handy guide, which we update every couple of weeks, that updates any changes in the various states regarding leaves, as well as other laws relating to COVID-19. And this is a snapshot of our guide, which is available in our current insights page, I believe.
Yes. And the asterisks, the bright green asterisks are the leave provisions.
Right. So that's available to you for your use. So finally, once you determine what leaves apply, the next thing that the employer will need to consider is how to communicate this information to the employees. It's not enough that the employer has decided to offer the FFCRA or has determined that they are obliged to provide leave under the state statutes. They have to also communicate this to the employees. Under the federal FFCRA leaves, there is a poster that is available that must be posted publicly, that is accessible to all the affected employees. And there's a link to it here, and is also available on the DOL website. And then each state and local agency may also have notice requirements as well as model notices that must be provided or posted to employees that would be affected by those leave laws. It is important to communicate this information proactively to all employees, whether or not those employees may be affected by COVID-19, rather than waiting for those persons who may be affected by the virus to ask about those leaves. And then in addition to that, check your leave policies to make sure those are up to date and reflect these changes in local or state or federal law. Now, once you have determined which statutes apply, and once you've communicated this information to your employees, then of course the next step is to figure out how the heck you're going to pay for this and how you're going to get reimbursed. So the next step is step 4, which are payroll practices. So the first thing to do is consider changes that may need to be made to the payroll system. Leaves may need to be coded in a way that can be filtered or sorted for reporting purposes. And check your states for guidance on local taxes and credits. And also be sure to report in box 14 of Form W-2. And again, if you have any questions about how this is supposed to work, we encourage employers to consult with their tax advisors, their payroll vendors, and their accountants. So finally, when it comes to the federal tax credits, in June of this year, the IRS issued some guidance related to the calculation of the tax credit for the emergency paid sick leave and expanded FMLA that was granted under FFCRA in the following extensions. And generally speaking, as I mentioned earlier, employers can claim the tax credit and then get reimbursed for it through that tax credit. And they usually claim the tax credit on their quarterly federal employment tax returns, or the Form 941s. And heads up, by the way, there's a deadline for 941 coming up on August the 2nd. So just a heads up on that. So there are 2 other options available. You can either reduce your federal employment tax deposits, and if there are insufficient federal employment taxes to cover the amount of the credits, an employer can request an advance payment of the credits from the IRS by submitting a Form 7200 advance payment or employer credits due to COVID-19 for the relevant calendar quarter. An employer who varies eligibility or benefits related to the emergency paid sick leave or the extended FMLA by favoring full-time employees, highly compensated individuals, or those with more tenure would not be eligible for the tax credit, which is something that the IRS was very specific about highlighting. Wages paid after the September 30th deadline for the extension are still eligible for the credit if the wages paid are related to the leave that was taken before that deadline. So if it was taken between April 1st and September 30th of this year, but the employer did not apply for the credit until after that, they could still get that credit as long as it relates back to the wages that were paid during that time period. And finally, if an eligible employer pays wages mandated by a federal, state, or local law for leave that otherwise satisfies the requirements of the paid sick leave or extended FMLA under the FFCRA, the employer is entitled to claim tax credits for those wages. So that wraps up our rather whirlwind review of FFCRA and related statutes and concerns. Are there any questions that we can field before we move on?
Yeah, Patrick. So here we are towards the end of July, and with FFCRA being optional now, could an employer decide just to do it for August and September where they have not been doing it for January through July?
Yes, yeah, that's possible. It seems like not a lot of time left to avail themselves of that leave.
Might be a little late to the game, but hey, better late than never.
But it is theoretically possible, yes.
Good.
I had one more question that somebody asked and thought it's worth repeating.
Okay.
On, let's say someone offers to extend FFCRA, would that also cover the employer under the certain state law requirements? And my thought on that, Patrick, was that not necessarily, because the state law requirements might be different,
Right.
or requiring different requirements, if you will, for lack of a better term, than what the extended FFCRA.
It may or may not apply for the particular employer due to
Right.
size. There may be notice requirements that apply to the state law that doesn't apply in the FFCRA. There are any number of things that could be different from the FFCRA requirements that you have to take into account for sure.
Yeah. So bottom line, if an employer chooses to extend FFCRA, do not assume compliance with state law requirements.
Right, exactly. That's a good point.
Great. And I just wanted to add that we, today is a momentous day. We are all in the same room, me, Patrick, and Diane, doing this webinar, and that has not been the case for well over a year. So I have a little bit of the giggles as well, because we're all together, and, it's like we make faces, if somebody's phone goes off or something. So thank you for joining us today. So those of you that know me well know that I love talking about leaves. So this is one of my favorite topics. So through FMLA, we're going to go pretty quickly. And this is just a big overview. And then we're going to talk about details of how everything goes together and benefits considerations. And we will be sending these slides out, so don't feel like you have to take a bunch of notes. So who's subject to FMLA? Public employers of all sizes and local educational employers. That includes public school boards, public and private elementary and secondary schools, regardless of size as well. And then private employers with 50 or more employees. And you measure the employees for each working day in 20 or more weeks in the current or preceding calendar year. You'll notice I didn't say full-time employees. I just said 50 or more employees for each working day in 20 or more weeks for the private employers. So which employees are eligible for FMLA? Well, there's 4 general criteria. They have to have worked for that employer for a total of 12 months in the last 52 weeks. They must have worked 1,250 hours within the last 12 months. Oh, the first one is a total of 12 months, 52 weeks in the last 7 years, I should say. The second one, the hour requirement, is the last 12 months. And then work within 75 miles of 49 other employees, if they count themselves as one. On this one, just a quick, this is who is eligible for FMLA. If they work within 75 miles. You'll notice when I was counting the size on the employer, it's just 50 total employees. You could have one employee in each state, and that's going to be important on the next slide. If somebody works from home and not from an office, you would count them to the office to which they report or where they receive instruction. So if you had one employee that worked in New York and everyone else worked in Texas, then likely that New York employee would count as Texas and they would be included in that office when you're counting 75 miles. And then they have to have a qualifying reason for leave. Those qualifying reasons: birth of a child, care for a newborn, placement for adoption or foster care, to care for a family member with a serious health condition, the employee's own serious health condition, exigency of child, spouse, parent who is active duty service member, and then to care for a covered service member who is next of kin. Sometimes we forget about those military related ones, but they've been around under FMLA for several years now. The employer obligations. So you have to provide 12 weeks of unpaid leave within a 12-month period for eligible employees. Of course, the leave can be taken intermittently, and military caregiver leave is actually 26 weeks. We forget that sometimes. We want to say it's all 12 weeks. You have to maintain coverage under the group health plan under the same terms as they currently have. So if they're currently paying 30% of the premium, you can't charge someone 100% of the premium when they go out for FMLA. They still can only be charged 30%. They have to be restored to the same or equivalent position. And then you have notice and posting requirements. This is where we're going to get into the size and mile radius discussion. So let's say you are a school, and I know that we have some on this call. Let's say you are a school, and because you have less than 50 employees, but you're a school, you're subject to FMLA. But when we look at how many employees you have within a certain mile radius, you actually don't have any employees that would be eligible to take leave. Because to be eligible to take leave, I have to be within 75 miles of 50 employees, but the school itself only has 35 employees. What does this mean? It means as the employer, you still have to put up this poster. I know it's crazy. It is. And let's say you have 30 employees in Texas and 30 employees in New York. You have to put up the poster in each place, but you may not have any employees that are eligible because they're not within 75 miles of 50. So you're telling them about a right that they do not have. And I agree that it's ridiculous, and this will apply to some people on the call. But so if you have questions about that, let us know. But if you have 50 or more employees, period, you have to put up the poster. And if you have a handbook, you have to put it in there. Or a leave policy, and then, or if you don't have a handbook, that's either or, you have to distribute it to new employees upon hire. The other notice requirements are as the need or request arises. We won't go into all of these, just know that there are 3 main ones. The eligibility notice and the rights and responsibility notice are currently combined. And those have to be distributed within 5 business days of an employer acquiring knowledge of an employee's need for leave. There are many court cases that say this is any representative of the employer. So let's say that an employee calls their manager and says, hey, I was in a car accident and I'm going to use PTO for 5 days. That is a qualifying reason under FMLA. That is a serious health condition which has prevented the employee from reporting to work for more than 3 days. So even though that's the manager, somebody would need to send that person FMLA. And so if you're right now on this call and thinking, oh, our managers don't know this, this is why training on leave procedures and leave laws and FMLA is important, so that your managers know at least when to contact HR or when to contact the leave contact. And then the designation notice is after you have received the health certificate and you are deeming this person eligible or not eligible for FMLA. So that was FMLA at 200 miles an hour. And Diane looks like she wants to ask me a question.
Because you can tell, because we're in the same room together.
Yes,
Okay.
yes, I read the eye contact.
Jill, should we chime in a little bit on some distinctions with domestic partners and emphasize that they are not considered family members for FMLA purposes, but maybe for state?
Yes, excellent point. So, and it's just like Diane said, so the federal government doesn't recognize domestic partners or civil union partners. And so they would not be eligible under federal FMLA. An employer is always welcome to extend FMLA-like benefits, but you would have to be very, very clear in your language and your leave policies. But many states, California as an example, and you'll start to hear the same states repeated over and over again: California, New York, DC, Massachusetts. For many states, domestic partners, civil union partners, if there's a registry in the state, then typically the leave laws do recognize them for the leave. We also have an excellent toolkit on domestic partnerships. So please ask your advisor if you want a copy of that, and it goes into details about leave laws and HIPAA special enrollment rights, eligibility for domestic partners. Thank you.
Thank you.
So Americans with Disabilities Act, I bring this up because it interacts with leaves frequently, and it's not the main part of the discussion, as this is more employment law than benefits considerations, but I want to mention it before we go into state law and the other items of the benefits consideration. So ADA, who does it apply to? Which employers? It applies to employers with 20 or more employees. Indian tribal employers are specifically excluded. States have their own versions of ADA, I will add, and that could apply to Indian tribal governments, and it could apply, there are many states that have their own version of the ADA and applies down to 5 employees. So this is just federal. So which employees are covered by the Americans with Disabilities Act? Any employee with a physical or mental condition who is able to perform the essential duties of their job with or without reasonable accommodation. So if someone obtains a permanent disability, and even with a reasonable accommodation, they will not be able to perform the job, then they're not covered by ADA. A reasonable accommodation is not available, so you would not have to accommodate them. But so what are an employer's obligations when it comes to the ADA? You have to provide a reasonable accommodation to a disabled employee. This could be temporary or this could be a permanent disability. You don't have to do it if it would impose an undue hardship on the employer, and that's a very high standard to meet. And an accommodation can include a temporary leave of absence, equipment modification, modified schedule, working from home, part-time, not lifting for a period of time. The list goes on. And of course, there's always a poster requirement. But the reason I bring it up here is because of that highlighted portion. There's a famous case with UPS, the shipping company. UPS had a leave policy where someone could be gone for up to 12 months unpaid for a medical condition. But if you did not come back on 12 months and 1 day, you were automatically terminated. And so the EEOC found this to be a problem, and they brought legal suit against them. And so there's a press release on the EEO site. It's from several years ago. But yes, UPS got in trouble for this because even though I think we could all agree that 12 months is a generous design, there was no room in that process for reasonable accommodation. And so what the EEOC said was, so it was reasonable for you to hold this person's job for 12 months, but it's not reasonable that you could give them 2 more weeks and then they would return. There has to be that back and forth process. Each situation is different. And I just want to bring up that in 2017, there was a case with the 7th Circuit, and there was a ruling that these temporary leaves of absence, that the ADA shouldn't be seen as a leave requirement or a leave entitlement. But the circuit courts are in disagreement over this issue. And so best practice at this point is still to consider temporary leave of absence as something you would need to accommodate if you can do it reasonably, because this is even written into the FMLA regulations themselves. Okay, and then state leave. Those of you that like puzzles, this one on the right is an actual puzzle, and there are 10 differences between the 2 pictures, but wait till after the webinar to do that. So spot the difference. So when we think about state laws and leave laws in general, there are 2 different types of leaves. One is a leave entitlement. The employee is entitled to leave if they meet certain conditions. And typically with that entitlement, they are allowed to continue their health benefits, their health coverage. This would include FMLA, which we just talked about, FFCRA, because they are getting paid. Anytime an employee is receiving payment, that would count as an hour of service under the employer mandate, and under most eligibility rules, that means they continue to receive health coverage if they're getting a paycheck. And then when it comes to state laws, some of the states leave are entitlements to leave, meaning if they're not eligible for FMLA, they might be eligible for one of these others. That would include California's CFRA, which is California Family Rights Act, California PDL, pregnancy discrimination leave, pregnancy disability leave, the District of Columbia's version of FMLA, Massachusetts paid family and medical leave, New Jersey's version of FMLA, New York's paid family leave, and Washington's paid family and medical leave. This is not an exhaustive list. I just want to say that these are examples, and there are other states. It would be impossible to have, in this format, in this timing, to go over all the states. Then there are certain types of entitlements or leave requirements that are compensation only, meaning the employee has to be on one of the leaves described above, or they have to be on an employer provided leave or under an employer's policy. And if they are under one of those other leave entitlements, then this is how they get paid. That includes short-term disability from your company, long-term disability, PTO, sick leave, California's state disability insurance, paid family leave, District of Columbia's paid family and medical leave, New Jersey's temporary disability insurance, New York's disability program. So if someone is eligible for that, what is the underlying reason that they are entitled to leave? Okay, and then have your employees move because of the pandemic? This has been a big question. Lots of employees are telling their employers months later, hey, by the way, I've moved. Is this a big deal? Like for my unemployment taxes or, state income taxes? Everybody was kind of lax in 2020 and it wasn't a big deal. But if you still have employees that have moved in 2021, now's the time to straighten that out. Most of the states at this point would want you, if that is a permanent leave, then they would want you to resolve that with the state tax department. Again, that's outside of our realm, but you want to work with your accountants on that. I bring up Hawaii because I personally, in the last month, have talked to 3 employers where they're like, oh yeah, one of our employees permanently moved to Hawaii and that's where they work now. Good on them. Like, that's awesome. But Hawaii is also one of the states that has very strict requirements when it comes to disability coverage, statutory disability coverage. And it kicks in after an employee has worked there 4 weeks. So you would want to get in compliance with that state requirement. They also have requirements regarding medical coverage, which is also very strict in Hawaii. But that's just an additional thought. So that's just some considerations, what you should be thinking about with state and local laws. Now we want to talk about benefits eligibility. And this is why we are all here. Benefits compliance is our pool that we're in. So benefits compliance, what do you need to think about? So I always get 2 questions. When can I terminate them? Well, if we're talking about coverage, when can you terminate their health coverage? Here are some thoughts. If they are under one of those entitlements, FMLA, some of the state leaves, FFCRA, if they're receiving payment, if their salary is continuing, then you have to continue their benefits under the same terms and conditions. You can't charge them more, and they would still be eligible. Notice under the ADA, that's not a requirement to continue coverage. You just can't discriminate against people who are disabled. So if other people who are not disabled are allowed to take off 4 months unpaid for non-medical reasons and they get to continue their coverage, then you would want to provide on par continuation for those who are disabled with the ADA. So what if FMLA is exhausted or it doesn't apply? Or what if the state leave is exhausted and nothing else applies? So their leave entitlement is over. So then you look at your plan document. What does your insurance contract and what does your summary plan description say in regards to eligibility? Most of them will say you were eligible if you work X hours per week or you were on a leave entitlement. And then after that, it terminates. Once the employee is no longer eligible, you offer coverage for COBRA for reduction of hours. For FMLA specifically, COBRA is offered at the end of the 12 weeks if the employee doesn't return. Now, I know a lot of times we want to be more generous. We want to say, oh, you know what? I think they're going to only be gone 2 more weeks. Let's just continue them on the health coverage. 2 things on that. 1, it's never just 2 weeks. In 2 weeks, you get another notice that say it's 2 more weeks. And then before you know it, it's 6 months down the road and we never did anything about the coverage. Well, anytime you have a stop loss carrier or a fully insured carrier, you want to stick to the terms of the plan, because if you were more generous than that plan document allows, and then somebody who's out on medical leave, of course, they're going to be using the insurance. They have claims. And then the carrier red circles those claims and says, hey, we need to look into this participant who has $80,000 in 1 month for prescriptions. Are they eligible? And then in their investigation, they find out that they are no longer working and they've been on leave for 6 months. And the carrier could deny the claims. So even though you want to be generous, follow the terms of the plan document and what the law says. You could always subsidize COBRA premiums if you wanted to. So those of you that have 50 or more full-time employees, including equivalents, remember that if someone earned full-time status during the measurement period, they continue their eligibility through the stability period, regardless of the numbers of hours worked. So if they've exhausted FMLA, but they're still not back to work yet, but they're in their stability period, their coverage keeps going on down the road. So coverage termination, when they no longer qualify, they've exhausted their leave entitlement, they're no longer eligible under the plan document, you've looked at the stability periods, then the employee loses eligibility and COBRA is offered for reduction of hours. And right now we've got the ARPA assistance eligibility to consider. That's through September. And so a loss of coverage because of reduction of hours, if it's related to a medical leave of absence or whatever, even if they went from full-time to part-time, a loss of coverage for reduction of hours is an ARPA assistance eligible individual. And then going back to that question that I said in the beginning, I always get two questions. I get asked, when can I terminate them? And one is, when can I terminate their coverage? And the second one is, when can I terminate their employment? And we can't answer that for you. The ADA is certainly a consideration, but there are so many other factors to consider. Employment termination is a separate issue, and that is outside the scope of benefits compliance, and you would need to go to outside counsel on that or your employment law specialist. And I love this little guy, how he feels about math, because that's how I feel about math. How do I measure someone's hours if they're on leave? So let's say that little Timmy is on leave, but he's also one of my variable hour employees that I measure in a look back measurement period. So he was on leave for like 14 weeks during the last 12-month look back measurement period. You know, how do I calculate those hours? Well, if the employee is on FMLA, because FMLA was specifically mentioned in the statute for the employer mandate in the ACA, if an employee is on FMLA or any type of paid leave, they're receiving compensation, any hour for which they receive compensation, even jury duty, there are two methods for measuring hours in a look back measurement period, but really only the first one is used. You disregard the leave period and average the hours for the remainder. So if Timmy was out 14 weeks and 2 of those weeks were unpaid and beyond FMLA and 12 weeks were FMLA, you would look at his hours for the remaining 40 weeks of that look back period and just average the hours for the 40 weeks, divide by 40 and don't divide by 52. And then the second one is just your crediting average hours for the others. And so no one really does that. But if you have questions about it, you can ask. Okay. How do I obtain the employee's contributions during leave? So they're out. They're not getting a paycheck. How do I get them? Well, there are 3 methods, and this is to copy the FMLA provisions. You can permit the employee to prepay. Of course, that only works when the leave is foreseen. You can require the employee to pay during the leave, but of course, this would most likely be by personal check. And you can either have it per pay period or monthly, either one. If the payment isn't received and you want to actually terminate coverage, you would have to do advanced notice of termination. And COBRA would not be offered as a failure to pay premiums. So I stopped paying my premiums in the middle of FMLA. So my coverage is terminated. My coverage is still restored when I come back to work. And if I don't come back to work, I am offered COBRA at the end of the 12 weeks, and I would have a gap in coverage for the period of time where I didn't pay my premiums. And then I would say the majority of our employers fall in the third bucket. They permit employees to pay upon return. And if it's a large amount that the employee owes, they can spread that across several pay periods, even if it goes into the next year. How about, can they change elections? Can an employee who goes out on leave change their elections? If an employee is going out on FMLA, yes, this is written into the law. They can drop coverage during the leave if they want to. If an employee is going on an unpaid leave of absence, yes, this is also a permitted drop under the Section 125 qualifying events, but your Section 125 cafeteria plan document would actually have to provide for it. And they have an opportunity to change if the leave coincides with the birth or adoption of a baby. Remember that if that's why they went out, then they would have an opportunity there with HIPAA special enrollment rights. What about when the employee returns? Well, if coverage was terminated during leave, an employee would be reinstated to the previous coverage if they were out for FMLA and they returned in a timely manner. That's an important part. And then state leave, if the state leave provides for reinstatement. And then if coverage was terminated and FMLA and state leave don't apply, remember if you're with the 13 weeks, you can apply a new waiting period. This is part of ACA. You can apply a new waiting period or a new initial measurement period if that employee returns within 12 weeks. If it's 13 weeks or more, you can apply a new waiting period and a new initial measurement. But there are special rules for educational institutions. That break is longer because of summer breaks. And that's it. I know it was a roller coaster and we went super fast, but these are just considerations for you, things to be thinking about. And now Patrick is going to get out his crystal ball and take us into the future.
Thank you, Jill. This will be a very short trip or glance at the crystal ball, for it's murky. We don't really know what's going to be happening this year, but some of the things that we see that could be on the horizon include in the American Families Plan that the Biden administration has proposed, could include FMLA, federal FMLA that is paid. There is some dispute now about how that's going to be paid for. The administration proposal includes direct federal funding, but some Republicans are urging a tax credit approach, much like the ones that I discussed earlier. In addition to that paid FMLA, the American Families Plan would include 3 days paid for bereavement leave. And then finally, one of the proposals that are floating out there is the Healthy Families Act, and that could grant up to 7 days of sick leave funded by the employers. Again, we really have no idea if these will actually make it into law, and if they do, what form that will take. But these are some of the things that we're keeping an eye on. And of course, whatever happens, we'll keep everyone informed as to what ultimately happens. So that's it for our webinar today. We really appreciate you guys attending today. And if you have any questions, please just let us know. And we hope you have a great rest of your day.
Yes, thanks so much. Thanks for joining us. Amber, you want to take us out?
Yes. Thank you, Jill and Patrick, for sharing your valuable time and expertise with us today. To reiterate, today's presentation was recorded. We will be sharing the recordings in the Get Wise Wednesday emails and on the NFP website. If there are any portions of this call that you missed by Friday, you will receive an email with a link to the full recording. The PowerPoint slides used during this presentation will be shared in the same email. Lastly, for those who may have joined our call a little later and are certified with your PHR, your SPHR, or your GPHR, this webinar is pre-approved for a 1-hour recertification credit. In 24 hours, I will email the program ID number for you to record and submit to the HR Certification Institute. This credit will only be available to those who listen to the actual webinar, not those listening to the recording later. Additionally, you must remain on the call for the entirety of the webinar to be eligible for the credit. At the end of this call, a survey will populate in a new window. Please take a brief moment to complete the survey, as it lets us know what topics are important to our listeners and helps us make our education program as current and relevant as possible. That concludes our webinar for today. Thank you everyone for joining us, and have a great day.